welcome back to the legal video series presented by the Law Office of Joseph Abrams. I'm criminal defense attorney Joseph Abrams, and I answer your most common questions about federal criminal law in easy to understand terms. So let's take a look at today's question.
The bail process in federal criminal cases begins when the defendant is arrested and brought into court by law enforcement, or when the defendant responds to a summons and appears in court as ordered. This hearing is known as the initial appearance and is presided over by a magistrate judge. Prior to the hearing, the Federal Pretrial Services Office will prepare a bail report that is provided to the judge and both parties. The bail report discusses the defendant's personal, family, and financial circumstances and prior criminal record. At the hearing, the judge must decide to either set bail or detain the defendant pending trial, which, in large complex cases, can be a substantial period of time. It is important to note that at this stage of the proceedings, the prosecutor's position on bail is a very important consideration for the court. If the prosecutor is not arguing for detention, then some type of bail will very likely be set by the judge. However, if the prosecutor is arguing for detention, then defense counsel is challenged to strenuously argue why the judge should nonetheless set bail. There are two broad factors that the judge will consider in determining whether or not to set bail. The first is flight risk. Here, the judge considers the strength of the defendant's ties to the community. This can include things like, does the defendant own property in the community? Does the defendant have family ties in the community? Does the defendant go to school or have a job? Other considerations may include whether or not the defendant has a passport or has lived in other areas or countries, whether or not the defendant has prior failures to appear, and the length of the potential sentence the defendant is facing. The other factor is danger to the community. Here, the judge looks primarily at whether or not the defendant's alleged conduct in the charged offense or the defendant's prior criminal record involved any acts of violence or the use of weapons. When all is said and done, however, the most important factor, in my view, of whether or not a defendant is granted bail is the skill and preparedness of the defense attorney. It is absolutely incumbent upon the defense attorney to clearly and assertively present arguments to the court that show the defendant's ties to the community and that the defendant is not a danger to the community. These are not always easy arguments to make, particularly when the prosecutor is opposing bail and the judge is basically wanting to be convinced that the defendant should not be detained. So, if you or a loved one are charged with a federal crime, it's important that you consult with an experienced federal criminal defense attorney who is capable and prepared to make the strongest arguments possible for granting bail so that you are not detained pending trial.
This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. I hope you found it helpful, and we'll see you next time when I answer another of your questions about federal criminal law.